Hey everyone, it's Rob Ryder on Sunday, January 12th, 2014. Man, the month is half over already. Holy smokes. I called this video Court Administrator / Clerk of the Court, the two phases of the court. Imagine that. You got a couple of different things going on, and I didn't realize it myself until I started reading some of the paperwork closer, and I'm not going to say it makes it any clearer yet, but it would explain a few things. And so, while what I really like to be concentrating on is the citizenship with the city and what that means, I can see that we're going to need to have this part figured out, because when you go to get your citizenship at the city, they don't have any idea what you're talking about. They don't know the difference between an elector and a voter, even though you can show it to them in the law. Right? So they're making an administrative decision not to allow you to become a citizen of a municipality. Well, then you have to get the courts involved, because there's a controversy. And this is one of the important things is we'll look at a few things that will, basically the Supreme Court of Michigan is saying the courts only get involved when there's a controversy. So we're not going to court. When we're going to an administrative hearing. That's not the same as a judicial hearing or a judicial setting of the court. That's where we need to be. And we're going to see more about that in a bit. My email is courtofrecord@aol.com, and phone number 616-712-6179. And, if you have a comment or whatever on these videos and so forth, if you put that stuff on YouTube, I don't read that shit. I ain't got time. Right, if you want to talk to me, send me an email, courtofrecord@aol.com. And if you're not on my email list, you may want to be sure to put in the subject line, add email list, because I do emails other than just these videos. And so if you're just watching the videos, you may not be getting everything. Donate. Yes, I am talking to you. If you can donate, please do. This is what I do all day long, as much as I can, till I can't take it anymore. Then I go to bed, and I get up, and I go do it again. So, if you can, please donate. PayPal account is, the name on the account is Ashley Rytlewski, ASHLEYRYTLAWSKI @gmail.com. See, I make it even hard to do. I mean, you really have to want to donate. Who's going to want to go type that into PayPal to send money? But there it is. Or there's the snail mail. Robert Rytlewski, RYTLAWSKI, 10955 14 Mile Road, Rockford, Michigan, 49341. Okay, so a lot of this started with this. I was looking at this form, Grand Traverse County, Michigan, Circuit Court Administrator, job description. Pretty dry shit to read. I had this section in here that you read enough stuff, you say, well, this is interesting. Prepares case files and conducts court hearings. Well, who would have thought a court administrator conducts court hearings? But yet there it is, as part of the job description. And conferences with pro-per parties and their counsel. Pro-per, proper person, in personam jurisdiction. It's a court of chancery, right? It's not in rem. When you go into court now with them frickin', numbered courts like 13th Judicial Circuit or 18th Judicial Circuit or 36th Judicial Circuit or whatever the hell they call it, right? You're going into an in rem jurisdiction. You want to go to pro-per, which is proper person, which is in personam jurisdiction. You do it by going to the court administrator, because they can conduct the hearings. That includes the pre-trials, the final conferences, and show cause hearings. That would be a subpoena. The court administrator, circuit court administrator, right? It doesn't say circuit court clerk, it doesn't say circuit court judge. Circuit court administrator can do a show cause hearing. Out frickin' standing. Settlement conferences, right? Can we mediate this before we have to go to court? You guys want to work it out back here, back in the back room? You do it with the court administrator. facilitates the resolution of cases before trial. authorizes bench warrants for criminal cases, authorizes legal documents for the judge with discretion. In other words, he can authorize orders for the judge. Right? He can issue warrants, he can issue subpoenas, he can issue discovery, whatever. It's done with the court administrator. Who would have thunk? So, right. So that's just one little piece of information. We should see what else it has to say. What else we got on here? Provides comprehensive service, approves. Yeah, there's all sorts of things to do. And they supervise a lot. Right. That basically they're the CEO of the court on the judicial side. Now, we're going to look at a couple of court cases that were in Michigan, not because of what they are, but because of little details they gave. So this one was some guy that Burbach, who was, or Buback, who must have been a county officer of some kind, got in trouble. So, one of the things they can do is remove him from office, let alone the criminal. The crime he's committed, he can also be removed from office. And so that's what this was about, and how it was done, and was it done properly, and yada, yada, yada. Hang on just a second, please. Okay. So the plaintiff originally sought to prevent the holding of a removal proceeding under some compiled law of 1948 prior to completion of criminal prosecution against him arising from the same circumstance. Right? So he was saying, hey, you can't remove me from office until the criminal prosecution's over, says I was guilty of something. It was claimed that to hold such proceeding would violate the plaintiff's privilege against self-incrimination and deprive him of procedural due process. Okay. So, to conduct an inquiry into the charges made, at which he will proceed to examination of witnesses in relation to such charges before some circuit court commissioner or any judge of probate who may be appointed by the governor for such purposes. So basically what they're saying, the governor can direct the attorney general to do this, the prosecuting attorney, or to conduct an inquiry before a guy who was called the circuit court commissioner or any judge of probate. Now, circuit court commissioners no longer exist in Michigan. They were 1963, they got rid of them, but this is a compiled law of 1948, right? Been amended, whatever. But at the time it said what it said. So these circuit court commissioners, what they could do is they had the power to do everything that a circuit judge could do at chambers. Not in a courtroom, at chambers. Issue subpoenas, issue writs, conference hearings, all the things that we just read that they could do here, that now that this guy can do. Right, this is the court administrator. Conduct court hearings, conferences of proper person parties, pre-trials, conferences, show cause, so forth. Those are the things a court commissioner could do. So they could either hold this before a court commissioner or any judge of probate, who may be appointed by the governor for such purposes. And when they do it, they shall observe the rules of evidence followed in chancery cases and shall have authority to rule on questions of procedural law. So however they do this, it's going to be by the rules of a court of chancery, not a court of law. And we're looking for the court of chancery. No person exercising power of one branch shall exercise powers properly belonging to another branch except as expressly provided in this Constitution. So what this is about is it's really the governor's duty as the chief executive to relieve somebody from a county office. It's not really a judicial function. It's a administrative function. And so to have a judge do it would have a judge who's supposed to just be dealing with judicial matters, right? Exercising executive powers. And that would be no separation of power. Because in Article 6 of the Michigan Constitution, it says the judicial power of the state is vested exclusively in one court of justice. It will be divided into one Supreme Court, one Court of Appeals, one trial court of general jurisdiction, one circuit court, one probate court. It's only supposed to be one probate court, one circuit court, one appeal court, one Supreme Court. Well, then how come in my county, whatever the number is, I think it's 18th Circuit, the 18th Circuit Court. If there's only one, how could there be 18, right? Actually, there's 83 of them, or however many counties are. They each have some court that has whatever number circuit court. Yet there's only one, and we're going to figure out why that is. And then farther on in the Constitution, it reads, in each county organized for judicial purposes shall be a probate court. The legislature may create or alter probate court districts of more than one county if approved, affected county by a majority of the electors voting on the question. The legislature may provide for the combination of the office of probate judge with any judicial office of limited jurisdiction within a county with supplemental salary as provided by law. So, you start with, we had one court of justice. It was going to have one Supreme Court, one appeal court, one trial court, one probate court, and then courts of limited jurisdiction that the legislature may establish by 2/3 vote. Right? So they haven't established these other ones yet, but they can. But start with, there's 1, 1, 1, 1, 1. But then it goes on to say in Article 6 of 15 that they're going to, in every county organized for judicial purposes, there shall be a probate court. I did a video that covered this stuff before, within the last couple months, I guess, where there are certain functions, ecclesiastic functions, that had to be done by the county court. They were considered probate functions. But then they went and they created these probate courts to take over the administrative functions of the probate judicial court. So they separated the judicial functions, which is really in probate, judicially, was to assign conservators, guardians, and things of that nature. And those were actually ecclesiastic. So my point is, when you see a sign that says probate court, it's just the administrative end of the probate court. It's not the judicial end. That's someplace else. But they have an administrative end of the court also. And it's the same with these courts, as they're going to say in this stuff when I get to it eventually, that all, like in Michigan, we have, let's say, 83 circuit courts, right? Circuit court, 13th Circuit Court, 16th Circuit Court, 18th Circuit, up to 83. Those are the administrative agencies of the court. But there is only one circuit court, and those are the administrative agencies. There's one circuit court. The administrative end doesn't handle the judicial part. It handles the administration, the execution of the law, basically, for things that don't require, because there is no controversy. They're all in rem proceedings. It's not, when you go into court today, you're not going into a court case that is an in personam, where it's this guy over here said I did something. It's a frickin', all they are is their property hearings to determine whose property it is. And because we're not taking it from that numbered 13th Circuit Court around the corner to the court administrator of the circuit court and saying, hey, there is a controversy, I don't know who the plaintiff is. Who is he to say he has any control over my property, because he's suing in the name of a fictitious plaintiff, or whatever the case may be. Things we've covered before. But So now we have these probate courts, right? And so these probate courts are that they're talking about here in Article 615 to me, in each county they're going to have a probate court, are these limited jurisdiction courts that were going to be established. That and what we call district courts, which we got later. Okay. The jurisdiction, powers, and duties of probate court and of the judges thereof shall be provided by law. They shall have original jurisdiction in all cases of juvenile delinquents and dependents, except as otherwise provided by law. So it's a very limited court jurisdiction. The probate court in the county. Not the one probate court that's part of the Court of Justice. Right? They're just calling this other court a probate court. But it's a court of limited jurisdiction. Supreme Court, Court of Appeals, Circuit Court, the probate court, and other courts designated as such by legislature shall be courts of record, and each shall have a common seal. Okay, and what the common seal is, a common seal is like the signature of the corporation. So, my intention isn't to go through all this, it's just to point out some things about if somebody is going to be relieved from office. The act of removing for cause is primarily administrative, and although judicial in a sense, not an act of such a nature that it requires performance of judicial branch of the government or permits an appeal thereto. Right? You can't appeal being removed for cause to the court. They're saying this is an administrative function. This is from the executive branch. The removal power here under consideration was assigned by the legislature to the executive branch of the state government. Even though the proceeding is an executive one, removal from office for cause is also quasi-judicial proceeding. It looks judicial, but it's really not. It's an executive function. And so when we go to court in these courts, it looks judicial, but it really isn't. It's the executive branch. Executive stuff is happening. They're administering the laws because we haven't said that there's a controversy between us and the plaintiff to somebody who cares. We keep going into the administrative only side and not into the judicial side of the court. The mere fact that it's conducted like in a judicial quasi-judicial fashion does not make it any less an executive proceeding. Right? People say that we're going into administrative courts. I'm not disagreeing. Hell, they're telling you that's what's happening. It may be noted that the second sentence, due process action. Yeah, okay. I really don't care about that. The statute permits removal proceedings to be conducted by a probate judge designated by the governor. Such a designation is made part of the proceeding required of the governor is assigned by him to the probate judge. And, this was tested here last year when Jason down in Georgia and his buddy, Jason, let's go on a couple years ago. They were trying to do a acknowledgement of deed. Before we go any further, don't ask me much more about the acknowledgement of deed. It's just one piece of many things that are wrong. And so just acknowledging your deed isn't going to save your property, right? And people they still email me today asking me that. No, it's not going to save your property. Pay attention. That's what we're working on. But he went down to do it, and the clerk said she wasn't going to, and she tore up his public record. He had gone down, and he had made this record, and had it notarized, and got a certificate of authority for the notary, so really it should be a public record at this point. She tore it up. He went to the probate court to complain, and that ended up being the place you would put a complaint in against an officer of the county. Probate court. And this is saying it here in Michigan that's the probate court is the one the governor has assigned for proceedings having to do with the removal of somebody from office. Now, I don't know if you're supposed to send your complaint to the governor first and he tells the probate judge, or you just go to the probate judge. But they allowed Jason down in Georgia to do it in the probate office. Pay attention. Now, this is the thing. By the judicial power of courts is generally understood the power to hear and determine controversies between adverse parties and questions in litigation. That's all the court does. They hear and determine controversies between adverse parties. And there is no adverse party in a foreclosure or any other in rem hearing. In fact, there isn't any in a criminal hearing because nobody's sworn a complaint against you. There is no adverse party. Now, to show this, this is a screenshot of motion slip, Circuit Court of County Bureau, Chancery Division, because now you can do all this stuff online. This is why you don't find everything in the dockets anymore. They're doing all their paperwork online. In fact, when Rowe and Brown went down to the Circuit Court, Cook County, to look at this, they found these by looking on the computer screen, and none of this stuff is in the court case. But what I want to show you on this, the only thing that's really important to me is right here. Is this a contested or non-contested hearing? Yes, non-contested. Right? So says the plaintiff. Because this went in from the plaintiff, and what's it for? Judgment for foreclosure. Non-contested. There is no controversy in a foreclosure. You had better go over to the court administrator and say, hey, wait a minute, wait. Yeah, there is. It is inherent authority not only to decide but to make binding orders of judgments, which constitutes judicial power. But it only has to do with frickin' controversies and questions in litigation. So I don't know what that means by that, in questions in litigation. I guess my question is, hey, has anybody put a complaint in against me? The legislature is also authorized to establish municipal courts in cities and courts of conciliation. That would be a small claims court. The courts referred to in this article are permanent organizations for the administration of justice, and it has been held that the term does not apply to those special tribunals which the law occasionally calls into existence for particular exigencies and which cease to exist when the occasion ceases. So for the administration of justice, right, the legislature was authorized to establish these other courts, like a municipal court or a small claims court. And technically, I believe that when you go for a foreclosure, it's a small claims action because they're not in a court of law. The only remedy the court could give you is damages. Right? Well, they're not getting money from you. They're taking your property. It's an MRM hearing. And this was because they tweaked back in the 1800s. They gave the courts of law some of the powers of a court of chancery, and the court of chancery some of the powers of a court of law. However, it still comes down to this: the judicial side of the court, not the administrative, but the judicial side of the court only gets involved if there's a controversy. And if there's a controversy, you need to bring the complaint, because they're not going to. They're going to say it's just a property hearing and there is no controversy. Or because the proceedings were preliminarily and collateral in the principal proceedings and the officer does not render final adjudication of rights to parties. Yeah, I'm not sure what that was about. But the exercise of judicial power, in its strict legal sense, can be conferred only upon courts named in the Constitution. So, the exercise of judicial power, in its strictest sense, which is to judge controversies, I guess, can only be conferred upon courts named in the Constitution. And we had one court of justice: Superior Court, Appeal Court, Circuit Court, Probate Court. The judicial power referred to is the authority to hear and decide controversies and make binding orders and judgments respecting them. However, for this probate court that they talked about, the one of limited jurisdiction, the duties which it imposes upon the court are not judicial in their nature, but belong to administrative branch of the government. Power in the governor to remove all county officers except county judges, judges of probate, and county clerks. Now, we're not supposed to have any county judges. We don't have a county court. Right? You can't find a building that says it's a county court here in Michigan. Yet, they're saying that by Article 8 in the Michigan Constitution that the governor can remove county officers except county judges, judges of probate, and county clerks. Courts of probate were established in each organized county. The jurisdiction, powers, and duties of such court shall be prescribed by law. Well, then they must be different than the one court of justice. Circuit Court Commissioner was substituted for a county judge as the person whom examinations of witnesses and removal proceedings might be held. This is kind of going through the different constitutions over time, how we got to where we are today here in Michigan. The one court of justice is the judicial branch. That's all there is. One court. It's the judicial branch. And it only gets involved in controversies. The Constitution of 1963 does not define the entire jurisdiction of the probate courts. This responsibility is left to the legislature by Article 615. Things provided by law. What does provided by law mean? Is intended that the legislature shall do the entire job of implementation. Where only the details were left to the legislature and not the overall planning, the committee used the words prescribed by law. So if provided by law, then the legislature is supposed to basically chapter and verse what the court can do. And so it would be interesting to see, because the Constitution didn't define the jurisdiction of the probate court, what the legislature ended up saying for it. Okay, so prior to this, does not pass the test, the survival test under 1963 Constitution. So the statute they used before doesn't pass the test. It imposes on probate judge a function of the removal process in a partial exercise of executive power because the legislature by statute placed the obligation and responsibility of removal, county officers, and the governor. All right. Well, this doesn't really have anything to do with what I want to talk about, but it's just interesting. So you're going to have to bear with me. The legislature may provide for the combination of the office of probate judge with any judicial office of limited jurisdiction within a county with supplemental salary as provided by law. So this office of probate judge they're talking about can be part of another judicial office of limited jurisdiction, not even be called the office of probate judge. The jurisdiction, powers, and duties of the probate court and of the judges thereof shall be provided by law. They shall have original jurisdiction in all cases of juvenile delinquents and dependents. Well, who has jurisdiction of juveniles and dependents? That sounds like the family court to me. Right, that the family court's the probate court. I'm not really sure. I mean, I'm going to think about that. I go back and look. Okay, well, who does have jurisdiction over juvenile delinquents and dependents? Whoever that is the probate court. It doesn't matter if there's a sign that says probate court on it. It's the one that has jurisdiction over juvenile delinquents and dependents. Whether the legislature did or did not intend those sections of the vest probate judges with executive power is of no present moment. Doesn't matter what they meant to do, they did do it, I guess what they're saying. So, yada yada yada. Okay. That was that case. Sorry, we got to look at one other one real quick. I'll try to make this one quicker. Then we'll get on to the stuff about the court administrator. But Bear with me. This was between the judges of the 74th Judicial District in Bay County. Now, the 74th Judicial District, right? The district court is one of those courts of limited jurisdiction that it talked about in the Constitution after the one court of justice, which was the Supreme Court, Court of Appeals, Circuit Court, Probate Court, and other courts, yada, yada, yada. This is one of those other courts that came out of that. And so they had just, this is like 1971, so they had just recently come into existence. And in the county, all the employees are in a union. Well, the union wanted to make all the employees of this court members of the union because they said they were county employees. And the court said, no, they're not county employees, they're state employees. And that was the basis of this hearing. Okay, but the interesting thing is, right, so this is judges putting it in. So let's see what the judges do when they put something in. It was an action commenced in the circuit court in Bay County, or lowercase circuit court. Didn't say the 18th circuit court or whatever the circuit court is in Bay County. It just said circuit court. By the filing on June 29th of a complaint seeking declaratory and injunctive relief. Right? So somehow these judges knew how to put a complaint into the lowercase circuit court in Bay County. The plaintiffs are duly elected and qualified judges. Bay County is organized county of the state of Michigan and under the law constitutes a body politic and corporate for that purpose. It's got a board of commissioners, which is the governing legislative body, and it's the district control unit. And basically, the district control unit pays for the district court to be there. So that's why they were saying, well, they're county employees. And so did the unions and so forth. District judges who are in fact a burden and responsibility of the state of Michigan. Okay, but what about the rest of the people? The district judges commenced this action seeking a declaratory judgment holding that the court's employees were not county employees, right? That they don't work for the county, they work for the state. And so it was hereby ordered and adjudged that the 74th Judicial District Court is a juristic entity, an integral part of the judicial branch of government of the state of Michigan, separate and apart from either the executive or legislative branches of the government, and as such is a political subdivision of the state of Michigan. The 74th Judicial District is a political subdivision of the state of Michigan. Right? If you're a political subdivision, you're a body politic. You're your own little state. I think that's how they get this sovereign immunity, because they have, see, that's their municipality, basically, is the district judicial district court. The 74th Judicial District Court is a juristic entity. Okay. Continuing on. Okay, that then basically that they're not, so the circuit judge who heard this said, nope, they're not part of the county. And he permanently enjoined, which I didn't go look that up, I believe that has to mean can't bring it up again from initiating this any further. It is further ordered that the scope of this judgment does not extend to bailiffs nor to probation officers. So probation officers and bailiffs must be county employees because they weren't covered in this. It says the appellant asserts the plaintiff could not prosecute this suit for a declaratory decree without first having exhausted the procedure before the township building inspector and the Board of Appeals as provided in the ordinance. In other words, they hadn't exhausted their administrative remedies. However, this contention of the appellants is not tenable. The court clearly discloses an actual controversy, or the record clearly discloses an actual controversy, decision of which does not turn upon any disputed issue of fact. Right? So what they're saying is you don't necessarily have to exhaust your administrative remedies, is bring up the fact that there's an actual controversy. Then it won't be administrative, it'll be judicial. MCLA 600-8101, the district court is established in the state. The district court is not a court of record. I have to question that because it does say it is a court of record. But nevertheless, the district court is not a court of record. The state is divided into judicial districts of the district court, each of which is an administrative unit subject to the superintending control of the Supreme Court. So the administrative units, right, that's what all the numbered things are. Like this is 74th District Court. There is only one district court, but it has numerous administrative units, and those administrative units are under the superintending control of the Supreme Court. And that'll be important. We'll see in a minute. Michigan has but one district court. For the administration of the district court, the state is divided into judicial districts. Like this is number 74. Mine's number 63B. Those are just administrative districts, but there is only one district court. And they're under the superintending control of the Supreme Court. A judicial district is an administrative unit of the district court. In each judicial district, there is a presiding judge who exercises, subject to the supervision of the Supreme Court, full authority and control over the matters of administration. Right? So if there's a problem with the administration, you would bring it to the attention of the presiding judge. But now what the presiding judge has done is he said, okay, I got too much to do. I'm going to take those type of issues and give it to this person called the court administrator. Employees of the district court are employees of the judicial district and administrative unit of the state's one district court, which in turn is a subdivision of the Michigan One Court of Justice. So the district court is a subdivision of the One Court of Justice. So I guess if you're going to do a complaint, you would put Michigan One Court of Justice, Circuit Court Division, because I'm going to take my complaint to the Circuit Court Administrator, so it would be the Circuit Court Division. So that's really what I wanted to point out, was just the fact that they're saying that there is only one district court. Doesn't matter that this is number 74. That's an administrative unit of the one district court. So when you walk into the door of the 74th District Court, you just walked into the administrative end of the court, not the judicial. We ain't going to get anything done in the administrative end. They'll tell you it's not that you're not correct. They're just not inclined to issue any warrants. Okay, that was a lot of that. What was all that for? Let's get to the point. Get to the point, Rob. Let's look at some things that have to do with court administrators. First of all, supervisor, the chief officer of the town, one of a board of county officers. Supervisor means an individual having authority in the interest of the employee to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, discipline other employees, responsibility to direct them or to adjust their grievances, hire and fire. Court administrator. An officer of the judicial system who performs the administrative and clerical duties essential to the proper operation of the business of the court, such as tracking trial dates, keeping records, court of record, entering judgments, and issuing process. Well, when I looked up issuing process, there's only two kinds. A process for issuing bonds, I found that, and that would be one of the things they do. But if we quickly skip down here to page 16, what's the real definition of issuing process? Process. Proceeds or issues forth in order to bring the defendant into court. In English law, process in civil causes is called original process when it is founded upon an original writ under the Great Seal from the Court of Chancery, and also distinguished from mesne or intermediate process, which issues pending the suit upon some collateral interlocutory matter as to summon juries, witnesses, and the like. Right? So those things aren't the original. The original is you go put your complaint in. In criminal cases, the proceeding, which is called a warrant before the finding of a bill, is termed process when issued after the indictment has been found by the jury. Words in the 12th section, the 5th article of the Constitution of Pennsylvania, the style of all process shall be the Commonwealth of Pennsylvania. That's what they're supposed to call them. Process defined as any means used by a court to acquire or exercise its jurisdiction over a person, over specific property, or over specific property. Means whereby the court compels appearance of a defendant before it or compliance with its demands. Okay? Well, we want to make ours over a person and get them in to in personam jurisdiction to say by what authority to bring this charge. Right? That you're committing, you brought fraud upon the court, whatever it is. So basically what they're doing now is an irregular process. The term is usually applied to a process not issued in strict conformity with the law, whether the defect appeared upon the face of the process or by reference to extrinsic facts, or whether such defects render the process absolutely void or only voidable. Under current practice, a defective summons may be amended under rule of civil procedure, yada yada. All summonses are defective. They have missing signatures, dates, check boxes. They have all sorts of defects in them. And you would take that to bring it to the attention of the court administrator. Because we want to do a legal process. Sometimes used as equivalent to a lawful process. Thus it is said that a legal process means a process not merely fair on its face, but in fact valid. But properly it means the summons, writ, warrant, mandate, or other process issuing from the court. Well, who can issue process? The court administrator can issue process. Okay, back to court administrator. Go between for judges, attorneys, and clients. Court administrator essentially runs the court's business. The behind-the-scenes work of the position ranges from scheduling the dates, of handling of all official correspondence. The handling of all official correspondence due at the court goes through the court administrator. Courts produce volumes of paper. The administrator's office processes them, accepting lawsuit filings, authenticating court documents, and issuing writs and summons. That's what the court administrator does, formerly known as the clerk. The post has evolved since the mid-1980s, but its technology has streamlined some elements of the judicial system, formerly known as the clerk. State and county administrators do essentially the same job. Unlike those in past decades, nearly all administrators today are appointed by judges. Judicial appointment has helped take politics out of this powerful position. I guess it is powerful because they can issue process. State administrators operate under statutory authority that entitles them to execute court affairs and provides an annual staff budget. They can execute court affairs. The court administrator is responsible for the entire court staff. And must delegate court duties accordingly. The administrator interviews, hires, trains new staff members, yada yada. The administrator implements employee policies, manages and schedules, makes certain each courtroom is staffed with a clerk and court reporter. Again, if you go to court and there's no clerk in there, you're not in court. you may be in an administrative hearing, but you're not in a judicial hearing, or there would be a clerk of the court in there. My opinion. So I think that's what they're saying. The clerk of the district court, known as the court administrator, is a public official. This office is created by Article, what is that? 4 or 6? 6. Section 13 of the Constitution of the state of Minnesota. Appointment of the court administrator is by the judges of the 10th Judicial District. Right? So the clerk of the district court is known as the court administrator. Who's the clerk of the district court? The court administrator. The court administrator is in charge of the administrative functions of the municipal court. The court administrator is a neutral party. He must not become involved in the preparation of the state's case by responding to defense discovery requests or determining what witnesses the state will need by issuing subpoenas. What did that say? Well, it said to me the court administrator can issue subpoenas and also respond to your request for discovery. Hey, where's the rest of the file? Administrator, you get the files ready for the judge. His file's bigger than mine. How come his has more paper in it? I'd like a copy of his file, please. Authentication, attestation, because it talked about they could do authentication. An attestation made by officer of the court, which he or she certifies a record in due form of law, and that the person who certifies the document is an officer appointed to do so. Example, a court administrator. Deputy certifies that the judge is a judge, and the judge certifies that the court administrator is an administrator or deputy. But what is authentication? In the law of evidence, the act or mode of giving authority to legal authenticity to a statute, record, or certified copy so as to render it legally admissible as evidence. So if you have a certified copy of something, you need to take it. Let's say it came from the court. I want a certified copy of that record out of the court, and they give it to you. You need to go find the court administrator and say, okay, I need you to authenticate this copy. So then you can give it as evidence. In Alaska, what's it say? An authenticated copy is a copy which is attached to, is attached an authentication in which the clerk of courts, again, we're talking about probably the court administrator, that the document is true and correct copy of the original document which is on file with the court, and a judge certifies that the clerk signing the attestation is the clerk of the court. The attestation is in proper form. So, man, you got to get, first of all, you got to get something on there from the clerk that says it's a true copy, and then you got to get a judge to sign it. He's got to certify for the clerk. That's some high-level stuff to get an authenticated copy. Investigatory grand jury, a judge, constitutional state referee, or 3 judges of a superior court, appointed by the chief court administrator to conduct an investigation into the commission of a crime or crimes. The court administrator appoints a jury. So if, right now, in federal court, they don't call them court administrators, they call them clerks of the court or something like that. We'll get to that in a second. But let's think about this, right? You have this indictment, and it came from a grand jury, but it's not been signed by the jury foreman. There's all sorts of things I pointed out in an indictment. Indictment shakedown, go watch that. So who do you bring that complaint to? Well, to whoever is the chief court administrator in a federal court setting. Because it's their job, they're the ones who assign people to the investigatory grand juries. New Jersey. Contents of a complaint, arrest warrant and summons. Acceptance of a complaint, the municipal court administrator or deputy court administrator shall accept for filing every complaint made by any person. You're in New Jersey, you want to put a complaint in, the municipal court administrator or deputy court administrator shall accept for filing every complaint made by any person. This is going to tell you that it has to be in a form approved by the Administrative Director of Court Services, or courts, I guess. Right? But That's how you do it. You want to put a complaint in, the municipal court administrator or deputy court administrator shall accept for filing every complaint made by any person. We've been looking for the proper magistrate to put our complaints before. New Jersey, hey, it's court administrator. New York law. Functions of a chief administrator of the courts. Act as the chief executive officer and exercise the functions, powers, and duties of a public employer under the provisions of Article 14 of the Civil Service Law. Forgetting that, they're the CEO. Well, we know CEOs got the juice and the power, man. They're over everybody, underneath them. Now, attorneys, it was either Blackstone or Koch, and I believe it was Lord Koch, said that attorneys are officers of the court, and they're always considered in court. Attorneys are officers of the court, always considered in court. And when they bring fraud upon the court, you want to bring that to the attention of the administrator. Because basically, they're working for the administrator. He's the CEO of the court. Trial court administration overview. What did I have this one for? Oversees budgets and physical operations. We'll get into physical operations here in a minute. This gal serves as the probate registrar, responsible for the day-to-day activities in the probate division. Now, again, this seems to me like they're talking about the one court of justice. This was for Michigan, and I put that part in about the one court of justice to remind myself. Because it says, right, it talked about the divisions of the one court of justice. Superior court, appeals court, circuit court, probate court, and then they added the district court. And they're all subdivisions. And this talks about the day-to-day activities in the probate division of the one court of justice. In Pennsylvania, Chief Deputy Court Administrator, records management. Now we're talking about, the record. And what did I find interesting in this? The Chief Deputy Court Administrator, his office is in City Hall. Right now we're talking about 1st Judicial District of Pennsylvania. The position was created in the Supreme Court of Pennsylvania. Right, so we're talking about a state court position, seems to me, and his office is in City Hall. I just find that kind of interesting. The Deputy Court Administrator for Legal Services responds to litigation and all legal matters relevant to the administration of business in the court. All legal matters relevant to administration of business in the court. Well, again, I think you would take a complaint to somebody like that the attorney of record in a foreclosure has brought fraud upon the court because the plaintiff is a fictitious entity. They don't exist. The overall responsibility of Delaware County District Court Administrator's Office is to ensure the timely and efficient processing of criminal and civil actions, including family-related issues. Family-related issues. Juvenile delinquents and dependents, or whatever it was. For the Court of Common Pleas, Delaware County. The Court Administrator's Office continues to process thousands of motions, petitions, stipulations, and applications which are filed each year. This is the Court Administrator. They didn't say we're not talking about going to the clerk's window and putting something in. This is the Court Administrator's Office. All right, this is just, I always thought, man, there's another court, something going on in another court we don't know about. Well, this appears to be what it is. They're doing it with the Court Administrator's Office. Yeah. In civil law, the Civil Court Administrator responsibilities include case assignments, processing motions, and statistical reporting. This lady here, which is this is all part of the same thing, if I'm not mistaken, this Pennsylvania thing. All right, that's who you're supposed to give your motions to, not in the frickin' window at the in the administrative branch of the court. No, it needs to go to the judicial side of the court. We're not putting anything into the court case on the judicial side. Criminal petitions, right? If you got a petition, complaint, whatever, because a petition is the same as a complaint, it's supposed to go to into this side of the court. Minnesota. Susan is the appointed court administrator. Serves as the clerk of the district court. What do they do in the district court? Well, civil, including implied consents, because they're implying that you've consented to things. That would be such as, what is implied consent instead of express consent? Implied means because of what you've done, you agree. Right? That there is no controversy. So that's like on your warranty deed. It's an implied trust because somebody paid $10 and you don't know who it is, and because of that, you got a partner and you're a joint tenant with somebody else. There's unknown beneficiary. But they processing of complaints, that's what they do. Maintain secure custody of all legal records. Well, we're talking about the court of record. Those are what the legal records are. The court administrator is responsible for all financial aspects of the court operations, including the collection of receipt of fees, fines, bonds, escrow funds. Who knows where the money is? File the money. Goes to the court administrator's office. They're responsible for physical activity. The court administrator also performs civil marriage ceremonies, having received the duties formerly assigned to justice of the peace. They're saying the court administrator is a justice of the peace. In Illinois, McHenry County is now accepting filing of civil documents electronically. Yeah, they would look, I closed it. That thing I had for Brown would look something like that. There is no paper. Attorneys must register with a circuit clerk. They'll be allowed to begin. But where do you bring the forms back to? Circuit clerk administration. To the administration side of the office. Ohio, a court administrator, physical officer. All business-related aspects of the court, managing all physical matters. She arranges and assists matters involving community participation in the court. Assist in matters involving community participation. Well, we want to participate in the court. She can arrange it. She can assist. She acts as an intermediary between the general public and the court. That's you and the court. She's the go-between. Not the clerk's window. The court administrator. What is fiscal? In general, having to do with financial matters, money, taxes, public or private revenues, belonging to the fisc or public treasury, relating to accounts of the management of revenue. Fisc, the public treasury. Hence, to confiscate a thing is to appropriate it to the fisc. They're confiscating your property and putting it in the fisc. Ohio, they got a guy called a judicial administrator, or a lady in this case. She retains and secures evidence, the record, as in the court of record, the record, and other important documents on court-related items. She has them. Where's the bonds that go with this case? Right? Where is the certificate of pendency for the lis pendens that's in the property file? Because a lis pendens is a suit pending, but it's not the suit. Minnesota. We answer hundreds of telephone calls and in-person questions per day. Again, this is the court administrator. Are you calling the court administrator's office? Who's calling them hundreds of times a day? We process paperwork, court filings, letters, motions, notices. We organize, retrieve, store, preserve, and copy files, paperwork, and record records of court proceedings. In some cases, stretching back many years. All right, they didn't talk about a docket form. Records of court proceedings. Spokane, Washington. The administrator serves at the pleasure of the Superior Court judges for Spokane County. These are appointed officers. Well, they weren't elected. And they implement the goals and decisions of the judge and the Board of County Commissioners. So they're also tied to that Board of County Commissioners. Judicial administration. An overview. Judicial administration consists of practice, procedures, and offices that deal with the management of the system of the courts. Judicial administration or administration of the courts has traditionally been concerned with overseeing budgets, selecting jury pools, assigning judges to cases, creating court calendars of activities, and supervising non-judicial personnel. Court administrators, or clerks of the court, accept the filing of court documents, maintain a file system of cases and a record of all final judgments, and process paperwork generated by judges. Court administrators are responsible for eliminating racial or gender bias in the courts, ensuring diversity in the court system, providing easier access to the courts for persons representing themselves without an attorney. This has nothing to do with the clerk's window, where people go to put their paperwork in. Presently, the leading issue in a court administration is certification of court interpreters for testimony given in languages other than English. Officers are of professional responsibility, which administer and investigate ethical complaints against lawyers, are also part of the system of judicial administration. Okay, back to this thing about interpreters, right? They're talking about English. Well, one thing about the United States is we don't have a national language. So I don't know what form of English they say. They say, can you speak plain English? I don't know. Is plain English different than Michigan English? I may not be able to speak it. I need an interpreter. I need to figure out why they don't understand that the attorney over there is brought fraud upon the court. Well, now I understand better. I'm not taking my complaint to the right side of the court. State courts are usually organized under the direction of a state court administrator who oversees legislative budgets, personal administration, court research, and planning. At the federal level, there is a clerk of court in each federal district who has duties similar to that of a court administrator. Whoever that clerk of court is the one you need to find in a federal court. And this is that thing about process again. So, alright. What else was there? What else was there? I found, we need to look at there's the judicial branch of the Constitution of Michigan. Supreme Court shall appoint an administrator of the courts and other assistants of the Supreme Court as may be necessary to aid in the administration of the courts of the state. General superintending control over courts, writs, appellate jurisdiction. The Supreme Court shall have general superintending control over courts, power to issue, hear, and determine prerogative and remedial writs. Prerogative writs are writs of the king, like a writ of mandamus, certoria, quo warranto. And appellate jurisdiction is provided by rules of the Supreme Court. You're going to find that sounds a heck of a lot like the circuit court when we get down to the circuit court here. Circuit court. The circuit court shall have original jurisdiction in all matters not prohibited by law. Appellate jurisdiction from all inferior courts and tribunals except as otherwise provided by law. Power to issue, hear, and determine prerogative and remedial writs. Supervisory and general control over inferior courts and tribunals within their respective jurisdictions in accordance with the rules of the Supreme Court. So the circuit court really has the same powers as the Supreme Court. It's just the Supreme Court, would have it over the circuit court, but anything below the circuit court has. County clerks, duties, vacancies, prosecuting attorney, vacancies. The clerk of each county organized for judicial purposes or other officer performing the duties of such office as provided in a county charter, so counties have charters, shall be clerk of the circuit court for such county. So the clerk of each county is who it should be. unless it's somebody else. And we get to it. I'll show you this thing where it talks about that these elected officers could have a defect, and if that's the case, that a deputy can be appointed to fulfill their duties. The legislature may provide for the combination of the office of probate judge with any judicial office of limited jurisdiction within a county. Still, I got to figure that one out. They shall have a common seal. To be qualified to serve as a judge of a trial court, judge of a court of appeals, justice of the Supreme Court, person shall have been admitted to practice law. I'm just trying to figure out, why do they use the word judge of a trial court, judge of a court of appeals, but in the Supreme Court they're called a justice. That's interesting. Justice goes with justice of the peace. Removal of domicile of judge. Whenever a judge, justice, or judge removes his domicile beyond the limits of the territory from which he is elected or appointed, he shall have vacated his office. We really want to see how the judge does his paperwork, because one of the things we're trying to do is establish our domicile. And you could do it by looking at their affidavit of candidacy. A judge of a court of appeals, circuit court, probate may become a candidate in a primary election for the office of which he is incumbent by filing an affidavit of candidacy in the form and manner prescribed by law. Anyways, I think when they do these affidavits, they have to put on these what their domicile is. More on that on another video, but just too much to talk about right now. But I wanted to get down to, where was it? Yeah. Okay, Circuit Court Commissioner and Justice of the Peace abolition, right? So they got rid of these things called the Circuit Court Commissioner, and they got rid of the Justice of the Peace, and then they're going to establish these other courts, which one of them they established for sure is the District Court. I don't know if they did other ones or not, but a Circuit Court Commissioner could perform all the functions of a Circuit Court Judge at chambers. Well, what are the powers of a judge at chambers? This is out of Montana, this thing about powers of judge. The judge of a district court may at chambers issue, hear, determine writs of mandamus, quo warranto, certiorari. These are the prerogative writs, other original remedial remedies, right? So these are the things he can do at chamber. This isn't in the courtroom. This is at chambers. These are the same things then that the Circuit Court Commissioner could do, and I believe today are the same things that the Court Administrator can do, because they can issue process, and that's what we're talking about. Issue, hear, determine writs of mandamus, quo warranto, certioria, prohibition, and injunction, other original and remedial writs, and all writs of habeas corpus on petition by or on behalf of any person held in actual custody in the judicial district. You're supposed to take your writ of habeas corpus to the frickin' court administrator. Grant all orders and writs that are usually granted in the first instance upon an ex parte application, one-sided application, and hear and dispose of those orders and writs. These are what they can do, right? This is the power of a commissioner who no longer exists in Michigan, but it's the powers at chambers. And that's what the commissioner had, and that is now what the court administrator has. Power of appointment to public office, Supreme Court, Court of Appeals, Circuit Court, or any justice shall not exercise any power of appointment to public office except as provided in this Constitution. Okay. Now this is the interesting one, or this is one of the interesting ones. Administrative action. In all final decisions, findings, rulings, and orders of any administrative officer or agency existing under the Constitution or by law, which are judicial or quasi-judicial and affect private rights or licenses, shall be subject to direct review by the courts as provided by law. This review shall include, as a minimum, the determination whether such final decisions, findings, rulings, and orders are authorized by law, and in case in which a hearing is required, whether the same are supported by competent material and substantial evidence on the whole record, findings of fact and workman's compensation proceedings, blah, 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 blah. So all that shit that's happening to you in that numbered circuit court, numbered district court, that administrative court, whether your foreclosure's happening or whatever, you can submit, because that's all executive, it's all administrative, you can submit that to the court through the court administrator saying, hey, I think we have a controversy here. They don't appear to be following the law. Right? And it can be reviewed. By what authority did they bring this charge? That's what we're talking about. And then property tax valuation. In the absence of fraud, error of law, or adoption of wrong principles, no appeal may be taken to any court from any final agency providing for the administration of property tax laws from any decision relating to valuation or allocation. Okay, well, that says in the absence of fraud, error of law, or the adoption of wrong principles. I think there's a very good chance that the guy that says that he is the county treasurer, that's on, when you look at your statement, it's going to be going to the county treasurer or somebody like that, that he hasn't taken the proper oath. He has a defect. Therefore, it's an error of law. So you can have it evaluated by the court. Treasurer has usurped, vacated the office, has not sworn the oath mandated by the Constitution. Possibly. And last but not least, justices of the Supreme Court, judges of the Court of Appeals, circuit court judges, and other judges as provided by law, and I don't know who they are, so we're going to go with those right there. Circuit Court, Court of Appeals, Supreme Court, shall be conservators of the peace. Well, what's a conservator of the peace? I thought I had that on here, but I don't. I don't know what a conservator of the peace is. Is that on here? No. That one was on justices. Conservators of the peace. Well, all I can tell you is their job, their responsibility is to maintain the king's peace. Now, if you download this book called Oxford Lectures and Other Discourses by Sir Frederick Pollock at archive.org, one of the lectures is on the king's peace. And the last page is what it says. We said that the king's peace and protection had become the established right of every peaceable subject. Nevertheless, a trace of archaic ideas persisted as long as the art of common law pleading itself. The right was to be enjoyed only on condition of being formally demanded. I demand the king's peace. In order to give the king's court jurisdiction of a plea of trespass, it was needful to insert in the writ the words vi et armis, which imported a breach of the peace, and it was usual, if not necessary, also to add expressly the words contra pacem nostrum, whatever that meant. Without the allegation of force and arms, the writ was merely vicontile. That is, the sheriff did not return to the superior court, but had to determine the matter in the county court. Right? So there has to be a breach of the king's peace for the writ to go to the superior court. We return to the superior court, not the county court. We want to return to the superior court. You need to demand the king's peace. And I'm thinking about this because back in the day when I had my talk with the two treasury agents, and of course, early on in the conversation, they said, well, are you one of those sovereign citizens? And I said, well, I'm not really sure what that is. I said, I consider myself a peaceful inhabitant. They said, you're a peaceful inhabitant? I said, yes, I'm a man of peace. I demand the king's peace. And boom, they didn't bother me the whole time I was there. Demanding the king's peace. And as it turns out, when you look, they are considered conservators of the peace. Treasury agents are. So, what else do we have? Okay. So, I hope you got out of this that basically we should be looking at somebody called the court administrator. And it looks like that's where you could put a petition in or a complaint, or you could get a copy of the record. You would put a motion in. If you're putting a motion in, it goes to them. It sounds like we're not supposed to be putting it in the window to the court that we normally do. That's just the administrative end. It's not the judicial end of the court. And so we're not putting anything into the record. So eventually they get a default judgment against us. Now, see, the county clerk is supposed to be, here in Michigan, she's supposed to be the clerk of the court, right? And it shall be the duty of the county clerk in all cases where bonds or other obligations are filed in any civil case, whether on the law or chancery side of the court, to record such bond or other obligation in a book in the office of such clerk to be kept for such purposes. But it goes on to say that this act shall not be enforced in any county of the state unless the board of supervisors in the respective county shall deem the recording of bonds necessary, yada yada yada. The first thing is, we don't have any board of supervisors. We have boards of commissioners. Is that what they are? County commissioners, yeah. The only supervisors we might have that would be a board of supervisors is when all the school, well, those would be superintendents. So what do they mean by a supervisor? There's the question. Supervisor could mean superintendent, right? But we don't have this board of supervisors. So I guess they couldn't have done this. However, here it is. It's one of their duties, right? So it's one of those things that just really throws you. But what this is showing is that there's two sides of the court, the law side and the chancery side. I don't think we're going to the chancery side to ask these questions. I think, and the chancery side appears to be the court administrator, because they can issue subpoenas and do proper person hearings, in personam hearings. One man against another man, right? It's not a property hearing. This is me saying, hey, you're committing fraud. You're trying to steal my property. And so you go to that side of the court with your court case and say, look, I don't have everything that's in the court file. I'd like to see the complete file. Because in the chancery side should be the item of indebtedness. Even if it's in the law side. First of all, we need to see the entire record, but I believe it's in the chancery side. And if you're in a foreclosure, then there should be especially in Michigan where they use lis pendences, which is a notice of pendency, suit pending. It's not the suit, it's a notice there's suit pending. Where's the suit? It's in the chancery side. When you go find that, it's going to say on there how much the controversy is. You can pay it right there and be done with it. Now, in each county clerk shall appoint one or more deputies to approved by the circuit judge, who shall be designated in the appointment of the successor of the clerk as a vacancy for any cause. So, right, the clerk's office could be vacated with them sitting there because it's for any cause. And whatever they do is supposed to be filed in the office of the county treasurer. And this is strange too. Who the hell is a county treasurer? All these things, because all these people could be who they are. However, they could have a deficiency and not be who they appear to be. But this is what a county clerk's bond looks like. The condition of an individual bond required under Section 61 of the chapter shall be in substance as follows. Something has been elected the office of clerk of the county of at the general election, yada yada yada, shall be required to faithfully, truly, impartially enter and record all orders, decrees, judgments, proceedings. That's what their bond is. This right here. They may have a penal bond, but this is the bond they're talking about. A piece of paper like this that has been filed with the, this is going to be filed with the county treasurer. County clerk, transmitting names and post office addresses of township and city clerks. The only reason I point that out is, what is the post office address, right? We need to have a post office address. We're not getting our mail because we don't have an address at the post office. This is about how many be appointed circuit court clerks. Duties. The county clerk of each county shall be the clerk of the circuit court for the county. Clerk of the circuit court for the county. Perform such duties as may be prescribed by court rule whenever in any statute of the state the designation register and chancery occurs. It shall be the clerk of the circuit court. Jurisdiction and power. Circuit court has power or jurisdiction in any of the following. I didn't put all these down, so possessed by the court of record at common law, as altered by the state constitution 1963 and the law of state, yada yada yada. Possessed by courts and judges in chancery in England on March 1st, 1847. Right? How come it matters in Michigan, a state of Michigan, what the laws of England said the powers of a court of chancery were? But if you want to know what the power of the court of chancery is in Michigan today, you need to go and look and see what it was in England in 1847. Now, this chapter contained to construe, to abridge the powers of the court of chancery, to compel the specific performance or agreements, impart performance of such agreements. We don't have excuse me. Now again, we're not supposed to have a court of chancery. That was abolished in 1848, something like that. Yeah, here we are talking about court of chancery today in the annotated laws or the compiled laws. Judgment or decree affecting realty, title, copy, recordation. That whenever any circuit court, court of chancery, probate court, or other court of record in this state shall have rendered any final judgment or decree by the terms of which a person shall be decided to be the owner and owners of the land of the state described therein, or where any person shall be determined to be the heirs entitled to inherit the lands, or the land shall be distributed, assigned, and partitioned, a copy of such judgment or decree duly certified under the seal of the court may be recorded in the office of register of deeds of any county or counties in which the land. See, and none of this has happened. There is no final decrees on any of this stuff, and we're going to go try to get one and then go record it with the register of deeds. And here's one I'm going to try: discharge of mortgage, certificate of mortgage. Okay, because I've done videos on this before. If you've ever refinanced your property and you go and look in your property file, chances are you're going to find a discharge of mortgage, satisfaction of mortgage, something of that nature. Okay, so any mortgage shall also be discharged upon the record thereof by the register of deeds, in whose custody it shall be, whenever there shall be presented to him a certificate executed by the mortgagee. And what we don't have is a certificate. I've got a discharge of mortgage, but it's not a certificate of discharge of mortgage, in my opinion, right? So I need to get the certificate. So I get it from the mortgagee or his personal representative to entitle conveyance of instruments of writing, yada, yada, yada. So we can do all this. In my case, what we're talking about is not for the land. I've already lost my property. This is for the securities that went with the mortgage. When the mortgage has been discharged, the securities should return to the owner. Well, I have this piece of paper says the mortgage has been discharged. What I don't have is a certificate. I've done numerous things with this in different audios or videos I've done, talked about. Still don't have my property back, so what could I try next? Well, now I know what I may try next. Okay, because I'm going to go, so there should be a certificate from the mortgagee. What if there isn't? Well then, or upon the presentation to such register of deeds of the certificate of the circuit court, signed by the judge of said court, and under the seal therefore certifying that it has been made to appear to said court that said mortgage has been duly paid. So I'm going to take the certificate of discharge that I got from the Register of Deeds office. It's not a certificate of discharge, excuse me. Discharge of mortgage. And take it over to the court administrator and say, this says that the mortgage has been satisfied. I need a certificate of the circuit court to that effect. Of course, I'm going to take this law and show it to him. Or upon the presentation to the Register of Deeds of a certificate of register in chancery, which is the county clerk, or the county under the seal certifying that the decree of foreclosure has been duly entered in his office, and the records in the office show that such decree has been fully paid and satisfied. Okay, so there is a decree for foreclosure. If you're in a foreclosure right now, I think what this is saying is in the chancery side of the court is a decree of foreclosure. Not a final decree, it's an intermediate decree. Can't remember what they call it. They got a name for it. It's one step before final. Okay, so you could go there and you could take care of the decree and show that it's been fully paid and satisfied and get the certificate and take it to the Register of Deeds. Interesting. The Register of Chancery referred to in this section is now the clerk of the circuit court. Well, who's the clerk of the circuit court? I believe it's the court administrator. When the public records are lost, a defendant in which shall be described all persons having claim, interest, and lien upon real property. So, when the public records in the office of the Register of Deeds, see, this is lowercase Register of Deeds, so I'm not really sure where that is yet. Again, it could just be the other side of the door of the Register of Deeds you walk into now. It's in all caps. Michigan, we have Register of Deeds office. When you walk to the door, big capital letters, Register of Deeds. Well, how come this is lowercase Register of Deeds and the sign is uppercase? It's because they're different. Of any county have or shall hereafter be lost or destroyed in whole or in part, fire, flood, disaster, like a man-made disaster, the circuit court in chancery for such county shall have the jurisdiction authority to hear and determine any suit instituted under the provision of this act and the rights of the several parties in the said suit. Right? So if there's a suit going on to determine whose property it is, because the defendants are all persons having or claiming an interest in or lien upon the real property herein described or in any part thereof, you need to go to the chancery side of the court. Chancery side of the court appears to be the court administrator. Upon the filing of a bill of a complaint, look at that, you can file bills of complaint. The circuit court shall enter an order for appearance and fix a time and place for a hearing. Said order shall be deemed sufficient for the purpose of this act. If the persons ordered to appear are described as all persons having or claiming an interest in or a lien upon property described in the bill of complaint, including their unknown heirs, devisees, legates, assigns, as the case may be. So, somebody put in a bill of complaint into the chancery side of the court, you didn't respond, they're going to take your property. You need to go find out if there was a complaint put in for your property on the chancery side of the court. Alright, here's that notice of pendency. The circuit judge may order such additional publications as the court may deem necessary to give reasonable notice of the pendency of such suit. That would be a lis pendens, suit pending. Alright? The court may order that printed copies of the order for appearance be furnished to the supervisor of each township for distribution to the residents thereof. It may order that copies be posted in conspicuous places of town halls, didn't say township hall, said town hall, school buildings, post offices, and other buildings where persons assemble, and that copies be mailed to all persons within the county having a post office address therein. We don't have a post office address. Oh, this is wonderful stuff. I got to read this one closer later on. Sorry. Methodist Episcopal Churches Act. Why did I put this in here? Well, because they have a way by such officer or committee as said annual conference may designate for the purpose apply to the circuit court and chancery. Who knows how to do it? The Methodist Episcopal Churches know how to access the circuit court and chancery within your county. Why don't you go have a cup of coffee and a donut with them this Sunday? Board of Supervisors. County Treasurer, separate office provided. The Board of Supervisors of each county in the state shall provide a separate and distinct office for the County Treasurer of their respective county. What does that mean, a separate office? Separate from what? Separate building? County Treasurer, maintenance of office in conjunction with other offices prohibited. It shall be unlawful to establish or maintain any county office in connection with the County Treasurer's office in any county in the state. What the hell's that all about? But transcripts of abstracts of records, a county treasurer shall upon request shall make upon request a transcript of any paper or record on file in the treasurer's office for the following fees. For an abstract of taxes, 25 cents. Abstract with statement of name and residence of taxpayers, 25 cents. Right? You want to find out what they have on you for 25 cents, they got to tell you. List of state tax lands on state bids, that'll cost you 25 cents for each description of land on the list, but you can go look at the list. For one copy of any paper document at 25 cents per 100 words. For statement in respect, for each certificate, 25 cents. For statements in respect to the payment of taxes required as amended, the county treasurer shall receive 20 cents for each description of land contained in the certificate, but the total amount shall not be less than $1. County treasurer, he's got to do some stuff if you go make him do it. He's got to give you the abstracts of this stuff. Deputy. The county treasurer shall appoint a deputy who, in absence of the treasurer from the office, or in case of vacancy in the office, or disability is a very powerful word, of the treasurer to perform the duties of the office, may perform the duties. All appointments and revocations of appointments shall be in writing. Treasurer shall not be responsible for the acts, defaults, misconduct of office deputies. That's his out. He's not responsible for them. He's going to keep his office at the seat of justice. You want to know where the seat of justice is? Follow the county treasurer. Each of the 83 county election commissions in the state is composed of the county clerk, the chief judge of probate of the county or probate court district, and the county treasurer. So, seems to me that if you want to know how to become a registered elector, the county election commission should be able to tell you how to do it. And you'll find out then who the county clerk is, who the judge is, and who the county treasurer is. Disability. The want of legal capability to perform an act. The term is generally used to indicate an incapacity of a full enjoyment of ordinary legal rights. Thus, a person underage, insane, convicts are said to be under disability. Well, yeah, and if you're not a registered elector, you can't vote in anything. Not a registered voter, registered elector. If you haven't taken the proper oath, you're not holding the office. You've vacated the office. Those are disabilities. And so, because the people that have been elected may have disabilities, they have to appoint deputies who don't have disabilities because somebody has to be able to do the work. Supervisor is chief assessor. Unless he's got a disability, then he's going to have a deputy. This is for the township. Supervisor is supposed to be the chief assessor, unless he has a disability, like he's not a registered elector, so he can't hold the office. Then there's going to be a deputy who shall possess the powers to perform the duties of the supervisor. Chief assistant prosecuting attorney. Why? Well, in case the prosecuting attorney has a disability. Chief deputy. Responsibilities of the chief deputy. Chief deputy may execute duties of the office of state treasurer during times of sickness or disability. They have a legal disability. Disability. County treasurer. This is township treasurer. Disability. Marriage of doubtful validity. Procedure to annul. You don't get divorced, you get an annulment. When a marriage is supposed to be void, or the validity thereof doubted, or any of the causes mentioned in 2 preceding sections, either party, excepting in the case of a contrary provision herein made, may file a petition or a bill in the circuit court of the county, where the parties of one or more of them reside, or in the court of chancery, annulling the same, and such petition or bill shall be filed, and proceedings shall be had thereon, as in the case of petition or bill filed in said court for a divorce. It'd just be an annulment. Right? Your paperwork's wrong, man. If you look at a marriage is the union of 2 estates, E-S-T-A-T-E-S, estates. It's a business contract. Township clerk, disability. So, anyways, if you just put the word disability into your state laws and start looking, you'll find all sorts of things that disability can be for. And there was one last thing, polling places. You got these different forms, right? There can actually be a certificate of electors sworn to disability. What the hell is that thing? They got a form for it. So, all right. Well, that was a lot of stuff about a lot of different things, but at the end of the day, it comes down to this. Circuit court. Now, I don't know that this is for the other inferior courts. It could be. You know what? You want to find out? You call them and ask them. But in Michigan, the circuit court administrator prepares case files and conducts court hearings and conferences with pro per parties. What is pro per? In personam jurisdiction. One man charged another man with a crime and willing to swear to it. And their counsel, including pretrials, final conferences, show cause hearings, settlement conferences, facilitates the resolution of cases before trial, authorizes bench warrants for criminal cases, authorizes legal documents for the judge with discretion, writs, subpoenas, they can do it. Circuit Court Administrator. Let's see what they can tell us. Okay, that's it. You all have a great night. We'll see ya.